Good morning. Welcome to this session of the 2nd District Court of Appeal. We only have 2 cases on the OA docket this morning. We're going to take the cases in the order in which they appear on the docket. If you haven't been here before or haven't been here recently, we allow 20 minutes to decide for oral argument. There's no requirement that you use all of that time. If you are the appellant and you wish to save any time for rebuttal, I'll allow you to save up to 5 minutes, and if you let me know when you approach the podium, I'll try to keep track of the time for you. Okay, the first case is Damianakis versus Philip Morris.
Good morning, Your Honors. My name is Sarah Palomar, and I represent the appellant, the estate of Damianakis in this case. And I'd like to reserve 5 minutes for rebuttal.
All right.
There's only one issue for you here today, and that issue is very simple, and that is whether Mr. Damianakis qualifies as an Engle class member. If he does, then the trial court's order granting summary judgment on the statute of limitations issue was error and must be reversed. Now, in this case, Mr. Damianakis qualifies as an Engle class member because he falls within the unambiguous parameters of the class definition as expressed in the November 21st, 1996 trial notice, and as ultimately approved by the Florida Supreme Court in their Engle III decision. The class definition in this case includes all Florida citizens and residents and their survivors who have suffered, have suffered, or have died from a smoking-related illness as of the class cutoff date of November 21st, 1996. This definition was first approved by the 3rd District Court of Appeals when it changed the definition in the Engle I case from including all United States citizens and residents to all Florida state citizens and residents. It then resulted in the trial court issuing a new class notice.
Did that become law of the case?
Excuse me?
Did that definition as approved by the 3rd District in Engle I become the law of the case in your view?
It did, Your Honor, and that's exactly what the Supreme Court held in the Engle III case, is that it was improper for the 3rd District Court of Appeals in Engle II to decertify the class because it had already been affirmed in the Engle I case, and thus the Supreme Court came back and said the class consists of all Florida residents fitting the class description as of the trial court's order dated November 21st, 1996. The class was established and did not change throughout the Engle litigation. Of course, in this case, Mr. Damianakis fits this criteria. He was, as of November 21st, a Florida resident who was presently suffering and who had suffered from a tobacco-related illness. He had been suffering for the past 2.5 years as a Florida resident, and he continued to suffer in Florida until his death in 2011.
So it's not disputed at all by any of the parties that he was, in fact, a Florida resident at the time that he filed suit. Is that correct?
At the time that he filed suit, at the time of the notice issue, and for 2.5 years prior.
And assuming that he does fall within the Engle class, there's no question, or at least it's not in dispute, that the time when he filed suit was well within the Engle time period. All right.
Now, the defendants are trying to complicate what should be a simple issue. They're arguing that in addition to the definition as expressed in the original class notice, that there is another requirement that is not expressed in the notice, and that one must also prove that they were either diagnosed with a tobacco-related illness in Florida or that they manifested a tobacco-related illness in Florida. And they cite 3 things in support of this. They cite the interlocutory order issued by the trial court on choice of law issues in 1998. They cite the Rearick case, and then they also cite the Bishop case. I'd like to address each of those in turn, starting with the interlocutory order. Now, what does this interlocutory order do that the defendants feel is so important? And what it does is it addresses choice of law. It says that it's dealing with choice of law. It goes through the significant context test, which is discussed in Florida on choice of law. In the middle of the order, it says that a cause of action by a class member accrues in Florida as a matter of law if that person was either diagnosed in Florida or first manifested his or her injury in Florida. And then it goes on at the end of the order to say, well, we're going to apply Florida law to the class. So does this change the class definition? Well, first of all, it can't change the class definition, regardless of what the trial court was intending, because people like Mr. Damianakis never got any notice that the trial court was going to change the definition. So what's the purpose of a class notice? The purpose of a class notice is to protect the due process rights, the procedural due process rights of both the plaintiff and the defendant. So the plaintiff gets plenty of notice that he or she's going to be bound by this lawsuit if he or she doesn't file an opt-out. And this is all taken care of very early in litigation so that the defendant's rights are also protected. So plaintiffs can't sort of shift in and out of the litigation as they see fit, as the merits may shift one way or the other. That's the purpose. Well, here Mr. Damianakis never got any notice that this definition is going to change. You can imagine him sitting in his easy chair on a Sunday reading the paper and seeing this class notice and saying, hey, I'm a Florida resident. I presently suffer from a tobacco-related illness. I have suffered from a tobacco-related illness. I'm a class member. Well, he would have had no idea that this definition was going to change, and that's a huge problem for defendants.
Well, wasn't the 1998 trial court order before the Florida Supreme Court in Engle III?
It was. It was. And in fact, insofar as defendants are now arguing that this order somehow changed the definition, that's not what they argued in Engle. What they argued in Engle all the way to the Florida Supreme Court is that this class is so broad. It includes people like Mr. Damianakis. It includes people who didn't manifest in Florida. It's so broad, and there's so many choice of law problems presented by this class that you must decertify Supreme Court. So throughout that litigation, they liked the fact that the class was broad because it made their decertification argument stronger. Well, of course, we know they lost that case. So now they're trying to, years and years later, sort of backstep and say, well, you know what, the class definition was always included this component of manifestation or diagnosis in Florida. That's not what they argued in Engle. And just to give you an example of a problem that could occur from their logic here, imagine if Mr. Damianakis had tried to file this individual action in late 1997 because his statute of limitations was coming to an end if he wasn't a class member. So imagine he filed an individual action in late 1997. That was after the opt-out period had closed. So he was definitely a class member, but before this interlocutory order came out. So what would have happened then is the defendants would have come in and said, Mr. Damianakis, what are you doing here? You're not a class member. You shouldn't be in court. You are a class member, and you shouldn't be filing an individual action here today because they didn't have the benefit of that interlocutory order at that time. And defendants would have completely harped on that argument and harped on the original class definition and kicking Mr. Damianakis out of court at that time. Well, now they're arguing the opposite. They're arguing, well, Mr. Damianakis, I'm sorry you were never a class member. I'm sorry you never got notice of this, but you really should have filed your interlocutory order, or excuse me, your individual action early on. Well, this is the problem, the logical problem with their argument, and that's why their argument can't work on things.
What do you make of the Rurick case?
Rurick and Bishop both suggest that there is a requirement of manifestation in Florida or diagnosis in Florida. First manifestation in Florida or diagnosis in Florida. I think Rurick is wrong, and I can tell you why it's wrong. It's wrong because they cite the Engle decision in support of the argument, and what Engle holds that you must be diagnosed with an injury or manifest your injury prior to November 21st, 1996. It doesn't hold that you must manifest and be diagnosed with your injury prior to 1996 in Florida. So that's a leap, and I challenge you to find anything in the Engle decision that suggests that. In both cases, both Rurick and Bishop cite page 1274 and 1276 of Engle. That is the portion of Engle that I'm referring to right now, and the Supreme Court simply didn't say that. However,
can you address this, please? Out of Engle 1276, the opinion in Engle III appears to discard diagnosis as a qualification, but goes on to say the critical event is not when an illness is actually diagnosed by a physician, but when the disease or conditions first manifested itself. But then, further on, the court expresses that our review of the medical records demonstrates that a class rep was formally diagnosed with lung cancer March of 1996, clearly demonstrating her disease had manifested by that time. So what's the legal difference between diagnosis and manifestation?
Well, I think the key there is manifest, and you must manifest prior to November 21st, 1996, and I think that's what the court is holding there, in the sense that it uses the word diagnosis. If you have been diagnosed with something, then obviously you're manifesting something. So I don't think that it's a huge discrepancy on the part of the court. I think what the court is holding in that section is that there's a cutoff date of November 21st, 1996, and you must manifest by that date. You don't need to manifest in Florida, it doesn't say that, but you must manifest by that date.
If we agree with you and decide to reverse, do we have to certify conflict with Rurick and Bishop?
And that's the point I really want to harp here. I don't think you do. and I really want to emphasize this, I think this is the key to our case. If you look at the class definition, there's two groups of people. There's those who are alive as of the class notice date, and there are those who are deceased as of the class notice date. So if you parse out this definition, you have all Florida citizens and residents who presently suffer or have suffered from a tobacco-related disease. That is unambiguous. That is Mr. Damianakis. Then you have the survivors of Florida residents who have suffered or who have died from a tobacco-related disease. That has an element of ambiguity because obviously if you're deceased, you're not a Florida resident. So if you're a survivor of a Florida resident who has suffered or has died from a disease, there is an ambiguity there because when do you have to be a Florida resident? Obviously you're not a Florida resident if you're deceased, which begs the question, well, when? And that's what the Weidner court struggled with because under that definition, someone could be born in Florida, could leave Florida, start smoking in another state, be diagnosed in another state, die in another state, and I think the Weidner court really struggled with that because that was the precise facts of that case. The woman in that case didn't suffer in Florida at all, never manifested her disease in Florida at all, went to Illinois where she was diagnosed and ultimately died. So the Weidner court struggled, probably a bit result-oriented in that case, and said, well, this is probably not the type of person that we should be including in this Engle class. It went out and it said, well, let's impose this requirement of manifestation in Florida or diagnosis in Florida. And I think that that's wrong because there's no basis for that. I think if the court's going to imply anything, what it should imply is just looking at the definition. Well, maybe if the definition includes the survivors of Florida residents who have suffered or have died in Florida, well, let's make them have suffered in Florida or have died in Florida. The court doesn't go that route, it goes the other route. The Bishop case, I think, is not very strong. The Bishop case is the opposite facts of Weidner. What happened in Bishop is everything happened in Florida. The guy was smoking in Florida. Everything happened in Florida. And then he was given 3 weeks to live and went to Virginia to die. And neither party, neither the plaintiff or the defendant in that case really argued that this manifestation or diagnosis test was the test. What plaintiffs argued was that the plaintiff in that case must have proven that he either suffered in Florida or died in Florida. The defendants actually argued, well, he has to prove that he actually died in Florida, and he didn't, he died in Virginia. And that was the debate in that case. The court ended up coming back with its opinion and citing the Weidner case, which really wasn't debated by either party, and so the court didn't really have the benefit of a thorough analysis in that Bishop case as it did in the Weidner case. But I do think that Weidner was wrongly decided. It does not matter, though, because our case is distinguishable. We are, quote, a Florida resident presently suffering and having had suffered from a tobacco-related disease. That's it. It's simple. It's a simple definition.
But Weidner does make a blanket statement applying a limitation or restriction to a particular plaintiff, which is contrary to the broad and open-ended class notice definition.
That's correct, and I agree. And I think it was.
So why wouldn't it be a conflict if we were to rule in your favor?
Well, I think because the facts are distinguishable.
But this is a broad statement. It doesn't appear to be specifically fact related.
Right, and I would hope in your opinion that you would distinguish it as being a different factual case, and that's why it doesn't need to, there's really no conflict here. Again, if you look at Weidner, we've got the survivor of a Florida resident who has suffered or has died. That's where the ambiguity is, because you cannot be deceased and be a Florida resident. We don't have that ambiguity with respect to a plaintiff who is alive, sitting on his living room, looking at this class notice, which clearly says, he's a Florida resident who's presently suffering and has suffered from a tobacco-related disease. He falls squarely within the confines of this definition, and therefore, we respectfully request that you consider him a class member.
All right. You've got 5 minutes left for rebuttal then.
May it please the court. Jeffrey Michael for Philip Morris, USA. I wanted to start by picking up on the January 1998 order, which I think is key in this appeal. And it was characterized as having somehow changed the class definition from what was given in the notice. And that's not what the 1998 order was doing. The 1998 order was describing requirements that were implicit in the class definition ever since in Engle I, the class was limited to Florida citizens and residents.
Well, if that's so, then why didn't the Supreme Court in Engle III cite the 1998 order and its specific language? Instead, they cited the language from the 1996 notice and expressly adopted it.
The Engle Supreme Court did cite the 1998 order. What happened was in Engle...
Where and what page? I can't find it.
It's page 1267.
Okay.
And what the language there is considering is in Engle II, the third DCA accepted our argument that you couldn't have a class action and you couldn't have a class-wide trial because you were going to have other states' law governing class members' claims. And the Engle Supreme Court in this section of the opinion is saying, no, the third DCA and...
But where's the statement in here that the Florida Supreme Court adopts the 1998 court language?
It says, first, the Engle II court ignored the trial court's pretrial ruling that only Florida law would apply when it stated that the choice of law analysis in the present case will require examination of numerous significantly different state laws. That choice of law ruling is the 1998 order. So what the Engle Supreme Court is saying is, no, third DCA, you were wrong, and my client and other defendants who are arguing were wrong when they said that you were going to have other states' laws in Florida apply to class members, and the Florida Supreme Court said, no, you're not, because of this 1998 order, which, if they're relying on it, they're saying that 1998 order was correct. And the 1998 order cannot be clearer that in order to be a class member, you need to manifest when you're in Florida. So if the Florida Supreme Court relied on the 1998 order to reverse the third DCA and to say it was okay to have a class-wide trial under Florida law, which resulted in findings made under Florida law, if the basis of that decision is the 1998 order, then clearly the Florida Supreme Court was adopting that 1998 order.
Well, if that's true what you're saying, then why would the Supreme Court on page 1277 emphatically say the class consists of all Florida residents fitting the class description as of the trial court's order dated November 21st, 1996? That is the only place in this opinion where they identify a particular interlocutory trial order by date. So why would they do that?
Your Honor, I can't get in the head of the crafters
So
of
doesn't
the
that
opinion.
conflicts with your argument as based on page 1270 or 1267? Because as I look at this, I don't see that language in Engle at all. And when I look at Rierich, the blanket statement that I was referring to with appellant's counsel, the qualification for membership, et cetera, you don't find that in Engle anywhere. You know where you do find it? In the 1998 order.
Yes, Your Honor, in the 1998 order.
Which isn't mentioned at all in Engle.
Well, I think it is mentioned in Engle. Now, why didn't they add a specific site to the 1998 order? I think that's splitting the hairs a little bit closely. It's clear that they were relying on the 98 order in order to solve the choice of law problems. Now, the idea that Mr. Damianakis somehow was relying on the class notice and would have filed suit. We had the picture of imagine Mr. Damianakis reading the class notice and thinking, should I file?
Well, what could be more important for setting the definition of who's in the class and who's not in the class than the definition of the class in the 1996 order and the notice that goes out pursuant to it?
That's certainly very important in defining the class, and the purpose is to give notice to class members. But there's been no suggestion here that Mr. Damianakis somehow ever saw that notice.
Well, that's not required, is it? They don't have to prove that he saw the notice. He was sitting in his armchair and he picked up the newspaper and read it. That's not an element, is it?
No, that's not an element. The argument, as I understand it, is that you're going to create problems with the notice. And the point I would like to make is, number one, those problems didn't exist here because there's no evidence of Mr. Damianakis.
Well, let me ask you the question that I asked opposing counsel. Is the definition in the November 21, 1996 order law of the case as a result of Engle I?
I'm not sure if law of the case is a specific doctrine would apply here, but the class definition in that 1996 order, yes, that is the class definition that applies in these cases. And
So how does the class definition get changed then to add additional requirements about manifestation in Florida, et cetera?
well, I think the class definition was not changed. It was construed to have implicit requirements, which happens all the time when you have a class notice and when you have a class action. The Florida Supreme Court itself added the November 21st, 1996 cutoff, which was nowhere in that class notice or class definition did it say in the 1996 order, by the way, your disease had to manifest by this date. Not in there. The Florida Supreme Court thought it was implicit in the date of the order. Similarly, the words manifested, diagnosed, appear nowhere in that class definition. The Florida Supreme Court said that it was implicit in that definition, and here the requirement that you manifest at the time you're a resident is not expressed in that definition, but both the Bishop Court and the Weirich Court said that it was implicit in the definition.
And I guess that's what I'm troubled with that, Mr. Michaels, because you're dealing with a huge case, and the Supreme Court of Florida already spoken on the subject. And if it was clearly their intent to limit or to add more requirements, don't you think they would have set that out very clearly in their opinion, and not leaving to the rest of us to surmise or to conclude that perhaps this is what's implicit in their opinion? I'm just concerned about that.
Right, and like you said, this is a large class of smokers, and the Florida Supreme Court in one decision could not craft something that dealt with the individual circumstances of every single alleged class member. So you've had the appellate courts in Florida, in cases like Bishop and Weirich, taking that definition and saying, well, there has to be some link between disease and Florida residency.
Yeah, but we're dealing with a concept that bars the ability to file a lawsuit. I mean, this isn't something that changes during a procedural posture of a case. We're dealing with a particular part of a definition that could restrict your ability to file suit. And we have a situation where the same trial judge, Judge Postman, issued these two orders 2 years apart. And based on your argument that the Supreme Court implied this restriction into the definition, then you'd have to argue that the trial court, well, he should have implied it in here, but he didn't.
Well, the reason the trial court issued the second order was it found Bishop and Weirich to be binding and to have happened after the first order. And if there is someone
No, I'm talking about Judge Postman. If Judge Postman's limitations in 1998 applied, then you would think, and this applies to bar certain litigants from filing suit, that it then would be incorporated into the 1996 definition, based on your argument. And it's not.
Well,
So can we assume that Judge Postman didn't intend this to be applied to the original definition?
I don't think that's correct. When you look at the language of Judge Postman's order, in paragraph 11, he talks about participating in the action. He says that people who do not manifest in Florida cannot participate in the action. And plaintiffs likewise agree in their initial brief that the 1998 order is talking about who can be a class member. That's in their brief at page 26. They say the 1998 order says you cannot be a class member. It's setting out requirements of class membership. And I haven't been able to get to my other point on what would happen if someone misread the notice and thought, I don't need to sue. If there was a case where someone thought, I don't need to sue because I'm in this class, but they didn't do so, there are other mechanisms to solve those couple of cases that might be out there to prevent a litigant from having slept on his or her rights because of the notice. And that would be either under due process or perhaps equitable tolling, since it's a statute of limitations issue. Those people could save their claims from the statute of limitations if they truly read and were misled by the notice. That's a much simpler way to solve the problem than to say that people can take advantage of the tolling and then the Phase 1 findings, which were made under Florida law, who did not fit the manifestation requirements of Judge Postman's order. Remember, the Engle Supreme Court said that all class members will have res judicata effect from the Phase 1 findings. And those Phase 1 findings were made under Florida law in a class action that was trial that was supposed to be for all class members, and all class members were supposed to have Florida law governed pursuant to that 1998 order, which the Florida Supreme Court admittedly did not specifically include a cite to, but they definitely were discussing that 1998 order and relying on it to reverse the third DCA.
Do you agree with the opposing counsel that the Rurick case is distinguishable, or if we reject your position and reverse the trial court, would we have to certify conflict with Rurick?
Well, I think it would be a conflict with both Rurick and Bishop. The idea that Rurick is distinguishable because it involved a deceased smoker, that was the first time I heard that argument. I don't think that works either logically or under the facts of Rurick. In Rurick, and you can see in the opinion, they have two diseases at issue, both COPD, which manifested in 87 or 88, and then lung cancer, which manifested after the move back to Illinois. So the smoker in Rurick was living in Florida in 1990 with COPD, so was suffering with a smoking-related disease. And I think with the court, both in Bishop and Rurick, they're looking at the residency requirement and the Florida residency and a Florida class action and saying, well, what does that mean? At what time do you need to be a Florida citizen and resident? And then looking at Engle and saying it's the time of manifestation, and looking at just the 1998 order. And so both courts are saying you need to be a resident at the time of manifestation. And I would submit, if this is a simple issue, we have the third DCA and the fifth DCA both getting that issue right. So I would think that this court would be creating a conflict by doing that. There was a suggestion in the brief that it was in some way dicta in Bishop because the court didn't necessarily need to construe that portion of the residency requirement, but it was certainly part of the basis of the court rejecting our argument that you need to be a citizen and resident at the time of death. They rejected our argument by saying, no, you need to be a citizen and resident at the time of manifestation, not death. So it's important to the logic of the holding, and therefore is not dicta. It will be like...
Oh, no, I'm going back to, in response to, I think, Judge Sleet's question, you've indicated, and going back, where in Engle does it make reference to the 1998 interlocutory order? You've mentioned a page number, and I did not write that down.
It's page 1267.
All right.
And it's the sentence that starts with first. The Engle II court ignored the trial court's pretrial ruling. And that's talking about the 1998 rule.
All right.
I don't think either party disputes that.
That's by inference, though. I mean, it doesn't mention it specifically.
I don't think it does not specifically cite to the record, but there is no other pretrial ruling that fits the choice of law analysis, and I think both Bishop Rear, the parties here, all agree that the court was referring to the 1998 order. And it's doing it to again, do something very important, which is reverse the third DCA and say, here's why you can have a class-wide trial. You can have a class-wide trial because of the 1998 order, and that 1998 order says that the class is limited to people whose claims manifested while in Florida. So with that, I would ask this court to affirm and align with Bishop and Rear. Thank
All right. Thank you, sir. Ms. Bellenbarg, you've got 5 minutes left for rebuttal.
Thank you. The Supreme Court held, and both Judge Sleet and Judge Stan pointed this out, that the class consists of all Florida residents fitting the class description as of the trial court's order dated November 21st, 1996. It didn't say fitting the class description as of the trial court's order dated November 21st, 1996 as modified or interpreted by the January 1998 interlocutory order. And this is a case with significant wide-reaching effects. There was a strong dissenting opinion in this case. So you have to assume that the Florida Supreme Court would have written that the class is going to be modified by this interlocutory order if that's what it had so intended. And it never intended that. Now, defense counsel harps on this 1998 order, and they say, well, the Supreme Court actually implicitly or indirectly cited this order. Well, it did, perhaps, but what did defendants argue that this order said to the Supreme Court? They never argued to the Supreme Court that this 1998 order changed the class definition. No parties argued that to the Florida Supreme Court. What the parties argued was that this order was just wrong. It applied Florida law to the whole class, and therefore the court should decertify. The Supreme Court came back and said, I'm not going to decertify. There's no problem here, and there's no problem with choice of law issues on remand because the trial courts applied Florida law to the whole class. It's as simple as that. The language which you should focus on is the unambiguous language suggesting that the class consists of all Florida residents fitting the class description as of November 21st, 1996. Now, the other point the defense counsel makes that I want to address is that he suggests that the interlocutory order is just sort of it implies, the original class description as contained in the November 21st, 1996 order is not modified by this interlocutory order, but that the interlocutory order simply expounds upon what the trial court really meant in the original 1996 order. Somehow there was an implicit requirement in this original order that a party diagnose or manifest their injury in Florida. Well, I challenge you to give that definition to 100 lay people outside and say, what is implied by this definition? And not a single one of them would say, well, you must have manifested in Florida and you must have been diagnosed in Florida. No one would say that because there's nothing that you could imply to reach the result that the Rear case did based on the language of the November 21st, 1996 order. And this is totally different than what the Supreme Court held in the Engle III case when they held that it's implied that one must manifest prior to November 21st, 1996. What the Supreme Court said there is it said, look at the definition. You must presently suffer or have suffered or have died from a tobacco-related disease. Everything is in the present or the past, and therefore it's implicit within the definition that you must have suffered or be presently suffering, so prior to November 21st, 1996. They took the language of the class definition and they expounded upon that, which was completely reasonable and based on the language of the definition itself. There is no basis for adding a requirement of diagnosis in Florida or first manifestation in Florida based on that original definition. And unless you have further questions, that's all I have.
All right.
Thank
Certainly
you.
an interesting problem and well argued on both sides, and we thank you for your presentation.
Thank you.